Well, hey again, everyone. It's Rob Ryder, and today is Monday, the 2nd of December, 2024. And again, it's J.D. Vance's turn to be up. So, J.D. Vance, Enlistee, you volunteered to be bound by and use the UCMJ. And don't let anybody tell you different, J.D. You're still a Marine. You'll always be a Marine. You've not been released from your enlistment. I covered that in my last video to you, so I'm not going to go into it too much right now. But because of that, we need to take advantage of the UCMJ because, brother, you're the closest thing an enlistee's ever had to power. You're going to be the Vice President of the United States, provided the guy who wants to be President of the United States, Donald John Trump, executes his oath of office properly to be the President, which he didn't do last time, but he's not alone. I mean, you can go back and watch every televised inauguration, and they all make the same mistake to invalidate their oath. They add their name into the oath, and then they say, "So help me God," at the end. And that's a religious test. Can't get away from it. It's a religious test because it's a prayer. It's a petition to the Lord to help you, which is different than like in the Pledge of Allegiance where you just say one nation under God. They say that's a patriotic use of the word. But a prayer has been defined by the Supreme Court to be a religious test. And since you are trained as an esquire, say you're an attorney, well, we're going to go into your paperwork. We're going to dig into your background in Kentucky a bit to see what you did to become an attorney. But because of that, I mean, you're trained in the law. You don't have any excuses. So we need you to step up and use today the UCMJ. You don't have to go to the black robe priest civilian courts. You could go to a general court martial convening authority, file some paperwork, charges and specifications under the UCMJ, and, get this thing going. We need you to do it. So we're going to talk about it a bit. And who am I? Well, I'm Enlistee Robert Allen. DOD ID number 12112800006. 8-year active duty in the U.S. Army, JD. AKA Rob Ryder. Email courtofrecord@AOL.com. YouTube videos are Rob Ryder with 3 B's on a Rumble with 2 B's. Made a mistake way back in the day. I never changed it. So what am I talking about exactly, JD? Let's just start with the simple things. Let's talk about oaths for a minute. All right, so the oath of enlistment is this: I, and a place to put in your name, and then what you're going to do. You're going to support and defend the Constitution of the United States. It doesn't say United States of America. It says Constitution of the United States. And obey the orders of the President of the United States. It doesn't say anything about the President of the United States of America. It says President of the United States. And orders officers over you, okay, and according to regulations and the Uniform Code of Military Justice. Well, we're going to spend some time looking at that because that's what we're going to use to push the rope. So, and I pointed this out last time, I mean, because of the law of commas, right? I could just say right here that I, Robert Allen Enlistee, do solemnly swear or affirm I will support and defend the Constitution of the United States against all enemies, according to regulations and the Uniform Code of Military Justice. I don't need that shit in between there. That's enough for me. I can go to the UCMJ, find the thing that somebody has done that violates a punitive article, file charges and specifications, swear to my complaint, all these things, and it should work. The problem is they won't recognize veterans as being in the military. However, at least for enlistees, we still are because we all joined during a war, and the war is ongoing. So anyways, that's the oath of enlistment. Now this 5 U.S.C. 331, this is the oath verbiage that you take as a senator. So, but its use is as an individual, except the president, elected or appointed to an office of honor or profit in the civil service or uniformed services shall take the following oath. Well, let's stop there. A senator or representative isn't part of the civil service. And they're certainly not in the uniformed services, so why are the senators and representatives taking this oath here that has a religious test, so help me God, built into it? When in fact, what they should be taking is the very first law ratified after or very first law signed into law by President Washington after the Constitution was ratified, like June 1st, 1789 or something like that. It was called 1 Stat 23, an act to regulate time and manner of administering certain oaths, which says the oath of affirmation required by the 6th article of the Constitution of the United States, again, not United States of America, Constitution of the United States, shall be administered in the form following. I, A.B., right, state your name, do solemnly swear or affirm that I will support the Constitution of the United States. There's no so help me God, but there is a place to put your name in. Well, who does that apply to? Because it said the people in the 6th article. The senators and representatives before mentioned and members of the several state legislatures and all ALL executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious text shall ever be required as a qualification to any office or public trust under the United States. I don't know what to tell you, JD, you took the wrong oath. So what about the president? Well, he's supposed to take this one. Before he enter into the execution of his office, he shall take the following oath or affirmation. I, see, there's no place here like an A, B to put your name in, or a line like they showed with the oath of enlistment. Just I do solemnly swear that I will faithfully execute the office of President of the United States and will do so to the best of my ability, preserve, protect, defend the Constitution of the United States, period. No, so help me God. And yet, as I showed in the last video, I actually showed Trump doing the inauguration where Esquire Roberts had him insert his name, Donald John Trump. I, Donald John Trump, do solemnly swear I will faithfully execute the office of the United States, office of President of the United States, and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. So help me God. He invalidated the oath. Trump was never the President of the United States because he didn't take the right oath. And so, now we got a headless bureaucracy that run around doing whatever they want to. Okie dokie. JD, if you were to go, this is from the Marines website, right? Every branch has got this, but I've got this on the Marine website just so you know it was the real deal. Manual for Courts Martial, United States. Well, in here, if we go to, right here, Appendix 1, Constitution of the United States. Well, that's what, so far, we've seen. Well, who are we supposed to be taking an oath to? Let's go back and look at that real quick. Let's just make sure, right? We got Constitution of the United States here, and then we're going to go down here and say, oh, the Constitution of the United States here, and then, well, the President, Constitution of the United States. So, yeah, looks like it's Constitution of the United States would be the proper name. Well, there it is, Constitution of the United States, 1787. Now, let's compare that to what the House uses. And the Senate, as far as that goes, it's called the Constitution of the United States of America, 1787. Well, that doesn't seem right. Is it just a misprint at the top, or what? As I'm going to show you, no, it isn't a misprint. This is intentional. Like for right here, it says Constitution for the United States of America. Here it says the Constitution of the United States of America. And we can debate, well, what's the difference between for and of? And while you're thinking about it, let's go down here and look at Article 2. Now, this is the one in Manual Court Martials. The executive power shall be vested in a President of the United States. And together with the Vice President, well, that would be you, choosing for the same term and doesn't have any years, be elected as follows. And let's compare that to this other one. The executive power shall be vested in a President of the United States of America. Wrong. And he shall hold his office during the term of 4 years. Well, that doesn't read the same at all as this other one. And this is the one, the manual court martials. Now, why is that important? Well, long before there was a Constitution, there was a U.S. Army and then a U.S. Navy. They existed before there was even a Declaration of Independence. And in the War of 1812, when the British came in and were burning up records, well, the Army took their records out and preserved theirs, where the Capitol got burnt. And I believe that's when they put in this fictitious Constitution to the United States of America. All right, they do is change a few words, da-da-da-da, slip them in, you know. Great forgers can do that kind of stuff. And so while we're in the manual court martials, which I'm saying, okay, well, that's what I'm using as my laws, whatever the manual court martial says. In fact, the Supreme Court, as we'll see, will agree with me that military justice is a completely separate system from civilian justice. And those that are bound by military justice are not tried in civilian courts. They have to be taken to a military court. So we got a whole bunch of people that were arrested for January 6th fiasco that were military, that were tried by an indictment, which is unconstitutional according to the Supreme Court. You can't try somebody in the military by an indictment. It's a violation of the Fifth Amendment. And then just so we can be sure then, because now we're talking about court martials, right? Jurisdiction in general, nature of court martial jurisdiction. It's entirely penal and disciplinary. And a court martial always has jurisdiction to determine whether it has jurisdiction. Otherwise, for a court martial to have jurisdiction, blah, blah, blah. So if you submit it to them, then they can decide if they have jurisdiction, but you got to give it to them first. So who can take something to a court martial? Actually, to a court martial convening authority, who will then get the rest of the show going. But, step one. And then, so who can? Well, that's in Rule 301. Who may report? Any person, A-N-Y, any person may report an offense subject to trial by court martial. To who? You know what's triable by court martial? JD? Things like fraud against the United States or conspiracy or, well, there's a whole bunch of them. We'll go look at them a little bit here in a minute. But, if you're trying to tell me that the Constitution of the United States of America is the Constitution, I'm going to say that's a fraud against the United States and take your ass to the UCMJ and have a military tribunal take care of you. That's how it should work. And I should be able to do that, except they won't recognize me and the rest of the veterans, enlistees, who are still in the military because we've never gotten a discharge order. And we're still bound by the UCMJ. It says so in the UCMJ. I'm going to show it to you. Just real quick, though, United States Senate. This would be the website for the group that you claim to belong to. It says in here, we're talking about oaths of office, and it gives the one that's out of 5 U.S.C. 331, and it tries to explain it. At the start of each new Congress, so forth and so on, take oath of office, new term. The Constitution contains an oath of office for the President of the United States, for other officials, including members of the Congress. That document specifies only that they shall be bound oath or affirmation to support the Constitution. Well, there's a little bit more than that, but that's where they decided to stop. They didn't mention, and no religious test shall ever be required. So in 1789, the first Congress adopted a simple oath. I do solemnly swear that I will support the Constitution of the United States. Well, yeah, that's in 1 Stat 23. It's a statute at large, and the statutes at large are still the law of the United States, according to 1 U.S.C. 112. Right? It's never been rescinded, so that's the oath. But then it goes talking about there was an outbreak of the Civil War, and we had to come up with this ironclad oath or test oath, right, and so forth and so on. And then, although Congress did not extend coverage of the ironclad test oath to its own members, many took it voluntarily. So you're taking the ironclad oath as it's been transformed till today, but you're not taking the constitutional oath that's required by the Constitution. And here you say it's the Constitution of the United States. But we go down here, well, the easiest one to always tell is just go look at the first sentence of the second Article 2 and see who has the executive power. The executive power shall be vested in the President of the United States of America. Wrong. The executive power shall be vested in a President of the United States. That's what the manual court-martial said. Executive power shall be vested in the President of the United States, together with the Vice President chosen for the same term. But there's no number of years, though, JD. You can see that, right? Here you're trying to say hold it for a term of 4 years, but that isn't how the Constitution was written. Right? That's a forgery. Is that what it would be? What a counterfeit? What would you call it? Bad counterfeit. Words don't match, but as close as they could do. And just to be clear, then in Article 1, it says that the legislative power herein granted shall be vested in the Congress of the United States. Okay, that's the one in the manual court-martials. And the one that's in the on your website for the Senate says the same thing. Vested in the Congress of the United States. So, if you're claiming to be the United States of America, then you don't have no freaking legislative power. So one way to get this all cleared up, JD, would be have like a court of inquiry or something look into it, which is all done under the UCMJ. And for a few minutes, we're going to look at this just to see if we could say, well, yes. Staff Sergeant Retluski, well, he's still under the UCMJ. Let's look at what it has to tell us. Okay, so persons subject to this chapter. Members, a regular component of the armed forces, check, including those awaiting discharge after expiration of terms of enlistment. Well, that sounds like me, because I don't have a discharge document. Volunteers from time to time, their muster and acceptance into the armed forces. Well, I volunteered, so check again. And other persons lawfully called, ordered into, or on duty in, or for training in the armed forces. Well, I could say that could be, and this part about inductees, that could be anybody who's registered under the Selective Service Act. And just call them into service. Okay, so I say that covered me. And who else? In time of declared war or contingency operation, persons serving in company armed forces in the field. Well, according to Trump, we've been under a declared war since December 7th, 1941, in the Legion Act. Him and Congress agreed the United States has been at war since December 7th, 1941. The wars never ended, and according to Title 10, United States Code, Section 506, as an enlistee, if you enlist during a war, you stay enlisted until the war is over, or your enlistment is terminated by the President or by Congress ending the war 6 months after Congress ends the war. None of that shit's happened, JD. We're still in. Can we find any more proofs? Let's see. Individuals belonging to one of the 8 categories of the Article 4 of the Convention on Relative Treatment of Prisoners of War, done in Geneva, so basically the Geneva Convention, right, has 8 different categories, which includes people that are in the Red Cross. So just a little sidebar here. If you had to go to court for some reason, because you're going to go to this court, the court you're going to isn't a constitutional court. Nobody has proper oath of office. So who are they? Well, they wear black robes, just like military judges do, and they have a gold fringe flag, and a gold fringe flag is an army flag. It is not a frickin' symbol of admiralty law. Whoever put that in somebody's head needs to be put against the wall. It's an army flag. The Navy don't have a damn thing to do with the law. So anyways, every courtroom you go into's got an army flag in there, or a military flag, not a naval flag, but a military land force flag. It's a symbol of jurisdiction. So either it's active or it's been captured. And if it's been captured, it's like what Lincoln did with Fort Sumter. He issued an executive order to get shit going. Said you got to give our stuff back because they captured all these United States arsenals and forts and so forth. And well, that's what they did. They captured the courtroom, or it's still a courtroom under the gold fringe flag. But if it's under the gold fringe flag, that's a symbol of military jurisdiction. And so anybody there is under the UCMJ because they are serving, accompanied an armed force in the field. Right? The Civil War never ended, JD. I talked about all this in my last video. I don't want to go into it too much again, but the truth is it never ended. There never was a proclamation or a treaty or order to end the martial law that Lincoln declared over the United States in his General Order 141. Okay, enough of that sidebar. Continuing on. The voluntary enlistment of any person, that would be you, JD, you're an any person, who has the capacity to understand the significance of enlisting in the armed forces, well, that's my job, make sure you understand that, and I'm doing it right now, shall be valid for purposes of jurisdiction under subsection A, and a change of status from civilian to member of armed forces shall be effective upon the taking oath of enlistment. You don't have to have anything in here about leaving that. It's just that's how you get in. There is no getting out. In fact, the Army calls us soldiers for life, for God's sakes. They even admit now that they have indefinite enlistments. It's all in the law, but nobody's taking advantage of it. And they're not going to let me do it, JD, but see, you slip through the cracks, brother. You're at the top now. You can come from above. So with all that being said, according to the UCMJ, under such regulations, the Secretary concerned may prescribe a member of the armed forces accused of an offense against civil authority may be delivered upon request to the civil authority for trial. But they got a whole regulation on how that has to be done. And there were a number of individuals that were active duty, military, involved in January 6th that were tried by an indictment. Forgetting the veterans, which I say are all included in the package, there were active duty that did that. And I'm sure that this wasn't followed. And so Article 21, jurisdiction of court-martial not exclusive. The provisions of this chapter conferring jurisdiction upon court-martials do not deprive military commissions, provost courts, or other military tribunals of concurrent jurisdiction with respect to offenders and offenses that by statute or by law of war may be tried by military commissions, provost courts, or other military tribunals. Is that what we have now, JD? Are our federal courts provost courts? Because they're not constitutional courts. There is no constitutional Article 3 judges. Nobody's taken a proper oath of office. They haven't satisfied the Constitution. Yet there they are, black robe, gold fringe flag, putting people in prison, taking their rights away. Who are they? You know, you got Esquire sitting out there acting like a judge, but he didn't take the oath to even be an attorney. What you had to do to start out to be an attorney, you got to first satisfy the laws of your state, and every state requires anybody who's going to be an attorney to take an oath. And so if we could find that paperwork for somebody like J.D. Vance and look at it and say, well, there's the name that J.D. Vance used on his paperwork. Let's go look at the shit he puts into court and see if he's using the same identification as he did to say this is the guy that has that's learned in the law, John David Vance, or whatever your name is, right? Or when you go to court, you sign J.D. Vance or John D. Vance or anything but John David Vance or whatever name is on your freaking certificate. That's what happens, J.D. When people hide their identity by providing incorrect names, and we just pretend that we're in court and they take all of our shit. So the way to stop that is to let veterans like me go use the UCMJ and say, well, brother, you can't do that stuff. I'd be a peacemaker. Or I'm going to go find who may convene a general court martial. Well, I'm going to go find somebody, right? The President of the United States can do it. Secretary of Defense, commanding officer, unified special combat, the secretary concerned, da 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 da. There's all sorts of people that can. Right? Who may convene a special court martial? Well, you got those people. Then you can do a summary court martial. That just requires just an officer. All right, summary court martial may, however, be convened in any case by superior competent authority when considered desirable by him. So whoever is in charge at the moment can, as long as he's a commissioned officer, sounds to me like he can convene a summary court martial. And then we have this section on military magistrates. Now, I need to ask you, is that who magistrate judges are in the federal system? Are they military magistrates, actually? Right, because it's an administrative office. It's not judicial. I say that that's, where the deception starts. Okay, well, this is where we're at now, right? This is how she gets done. Pretrial procedure. Article 30. Charges and specification. 1. May be preferred only by a person subject to this chapter. I say I am, so I should be able to prefer charges. 2. Shall be preferred by a presentment in writing, signed under oath, before a commissioned officer of the armed forces who is authorized to administer oaths. And of course, they have a section on the UCMJ to specify who those people are. But that's what it takes. Now, this says may be preferred. Does that mean they can stop me from doing it? Or they can try to stop me from doing it? Maybe I can do it. If I can get it in, I can prefer some charges. But whoever does it, they have to do it by a presentment. Now, presentment has a term in law, and it has to do with things a grand jury does. It's like, well, we don't have any grand juries, so I'm not really sure about the word presentment being used. But there it is. And then it says, see page 49. We're on page 11. Let's go look at 49 real quick, because I think this tells us, well, who can actually give us that authority to administer oaths, right? Following person, active duty, performing in active duty training, blah, blah, blah. These guys can do it. All judge advocates, all summary court martial. Well, all summary court, again, that's any commissioned officer. All you got to do is say he's doing it as a court martial. Now I can, take your oath. So forth and so on. And then the following persons on active duty may administer oaths necessary for the performance of their duties. So this one up here is including military justice. And these down here are for their duties. One of them is a recruiting officer. Well, a recruiting officer is, as far as I know, are we talking about the NCO sitting down in the recruiting office? That guy? They got a flag down there. Or are we talking about the guy at the MEP station? Because if we're talking about the enlisted man sitting down there at the local recruiting station, then he would have to do it because it's his job to support and defend the Constitution, which is what I'm trying to do. So it's one of his duties is to support and defend the Constitution and do shit under the UCMJ. Anyways, so we know who it is that could do this for us. Okay, and then finally, punitive articles, right? These are all the different things that you should be able to go under Article 30 and go file charges and specifications based on these articles, like conspiracy. Oh, you mean conspiracy isn't a theory? No, conspiracy is a crime. Imagine that. Failure to obey an order of regulation. Well, I say that's what's happened with us because I should be able to use the UCMJ, but I'm not being recognized as still in the military, although I've never gotten a discharge order. So somebody's violating a regulation. Aiding the enemy, public record offices, fraudulent enlistment, appointment or separation. Well, every governor doesn't have a proper oath of office. They're really not the governor, and yet they're usurping the powers of commander-in-chief of the state, which is, that'd be like an appointment once you're enlisted. I mean, not enlisted, but once you're the governor, you're appointed the commander-in-chief. But we don't have any because we have false official statements like oaths of office that aren't properly done. All sorts of things. Boom, 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 boom. Most of these are what we would call non-capital offenses, and so they could easily be investigated. Frauds against the United States. And then the general article, which allows you to cover everything else that you want to cover and that's not covered by something else. All sorts of things we could use. And then finally, a court of inquiry to investigate any matter may be convened by any person authorized to convene a general court-martial or by any other person designated by the secretary concerned. So we don't even need to have the court-martial first. We just need to have a court of inquiry, which requires somebody who's authorized to convene a general court-martial to convene a court of inquiry. And what they should do then is go to the Senate and go to the House and subpoena all the oaths of all the members of Congress to see if anybody did the oath that they're supposed to do or not. They should do it today. Okay, JD, about done here. Just wanted to show this. This is from the Congressional Research Service. I mean, these people work for you at the Senate. Military court-martial under the Military Justice Act of 2016. All right, this is Congressional Research Service report R46503, which says that the Supreme Court has called military justice a system of justice separate from jurisprudence in civilian courts. Members of the armed forces are subject to rules, orders, proceedings, and consequences different from the rights and obligations of civilians or of their civilian counterparts. Accordingly, it might be said that discipline is as important as liberty interest in military justice system. The Constitution specifically exempts military member accused of a crime from Fifth Amendment right to a grand jury indictment, from which the Supreme Court has inferred there is no right to civil jury and court-martial. However, in part because different standards provided in court-martial, there are jurisdictions limited to those persons and offenses the military has legitimate interest in regulating. They pretty much covered it right there. We have our own system. We're not in the civilian system. If the civilian system wants us, they have to go to the military and follow the rules to get you. And part of that is there's going to be a letter. In fact, I'll show you. I mean, it's all been taken care of. It's like the whole system, how it's supposed to work, is set up. We just don't ever use it. A couple more things and this will be done. And what I wanted to show was where I said the Supreme Court has called military justice a system of justice separate from jurisprudence in the civilian courts. Well, let's look at number 21. What is that? It's Parker versus Levy, which said, just as military society has been a society apart from civilian society, so military law is a jurisprudence which exists separate and apart from the law which governs and our federal judicial establishment. Members of the military aren't in that. We're in the military establishment, not the federal judicial establishment. And just really quickly then, in Army Regulation 630-10, what has to do with absence without leave, desertion, and administration of personnel involved in civil court proceedings. That would be the people that were involved in such, let's say, the shenanigans of January 6th. But really, this is any federal court case, as far as that goes, where it talks in Chapter 7 about the surrender to civilian law enforcement officials. And it goes on to say, this chapter establishes procedures and policies for the surrender of military personnel to civilian authorities. In the continental United States, there is no statutory authority for a commander to deliver a soldier to a bail bondsman or their surety. The surety must coordinate with the installation staff judge advocate and commander of the soldier prior to attempting to apprehend the soldier. To preserve peace and order in this installation, military police may be notified by the soldier's commander and occupy the surety to observe the surety's taking custody of the soldier. That's how this shit's supposed to happen. Approval on request to surrender soldier by court-martial, convening authority, or designee. The soldier remains assigned to the parent unit. I showed down here, where was this? Civil proceedings, a bond. As part of the surrender process, the unit commander provides the soldier a written letter of instruction. If the terms of the bond preclude the soldier from leaving the jurisdiction of the court, the appropriate commander requests instructions from commanding general, blah, blah, blah. Anyways, this is the letter that you should get. So anybody that was rounded up on January 6th, had anything to do with the military, especially if they're active duty, should have gotten this letter. Right? You are being released to the custody of civilian authorities pursuant to provisions of AR 63-10, Of course, it would be different for the different branches, but, you know, everybody's supposed to get a letter if they're going to release you to the civilian authority. How much you want to bet it didn't happen? So you may ask yourself, JD, well, Retluski, why can't you use the UCMJ? And really, it's just simple, because I can't get an ID card. I need an identification card required by the Geneva Conventions. That would be my proof. If nothing else, if I had the ID card, it would prove I was in the military. Then I could go to JAG or to the places where you can file paperwork, and I'd go file me some papers. And what's supposed to be on the card? Well, hang on a second. Well, according to this, the staff of the National Red Cross Societies can have it. So again, if you were to, you know, if you're not a veteran and you want to say, well, I'm under the UCMJ because I'm in the Red Cross, right? Go donate some money online. Donate $10. They'll give you a receipt, because there's 3 ways to become a member of the Red Cross. You can donate time, blood, or money. And once you get the receipt, you can say, well, I'm a member of the Red Cross. I demand trial by court-martial. Put on your brassard on your arm with a big red on there and walk into court and tell the judge, Judge, I'm a member of the Red Cross. I demand trial by court-martial. If you're a veteran, Judge, I'm a veteran. I demand trial by court-martial. I say I'm under the UCMJ. You know, and give the judge a chance to do something instead of saying, well, he won't do anything. Just tell him. Tell the man the truth. So ID requirements. Each party to a conflict must furnish certain persons under their jurisdiction ID card. Well, that would be people like me. The ID card shall show the owner's surname, first names, rank, armed force, regimental, personal, a serial number, or equivalent information, and date of birth. If there's anybody in the military watching this video, would you please look at your ID card and tell me if it has your date of birth on it? Because I do not believe that the ID cards that are issued by the military today, by the DOD, have your birth date on there. And so they violated their own frickin' instructions from the beginning. Okay, just a couple more minutes. I want to look at the Kentucky Bar Association website for a minute, because that's where J.D. Vance is apparently registered as an attorney. That is in the state of Kentucky. Or in the Commonwealth of Kentucky, I guess is probably the proper term, because when you search under Vance, you find, well, here's James David Vance, Cincinnati, Ohio. Right? Now here it says James David Vance, and here it says J.D. Vance. Now, how can that be? How can there be one or the other? Which one is it, J.D.? Which name was registered with the courts of Kentucky to be an attorney licensed to practice law? Although I see here that you have, I'm not engaged in the private practice of law. And when did you, last update, 11/26/2024. That was right after I did my other video for J.D. Vance, I believe. Maybe you came here and cleaned up your mess. Because you're not claiming to be registered to private practice of law. But let's see what that means. Hang on. Unfortunately, it just takes too long to get all the paper together and show every last detail, but these are from the Supreme Court rules of Kentucky, where it says under Rule 2.012, Oath of Allegiance, that no person who advocates overthrow of the government of the United States or of this state by any unconstitutional means shall be certified to the Supreme Court for admission and a license to practice law. Therefore, every applicant shall be required to take an oath to support the Constitution of the United States and Kentucky. Check. All portion applications except fee payment, so forth and so on. So you got to fill out an application. The applicant must give full and complete responses. So that would mean then when it says, well, what's your name? You couldn't put, how did you do it? Let's go back and look. James D. Vance, you'd have to put James David Vance. Well, if you put James David Vance, you can't use J.D. Vance to practice under. That name doesn't have any authority. James David Vance, with your bar number, for lack of a better term, is your identification to prove you're licensed to practice law in Kentucky. Now, it's just not you doing this. This is just common procedure with esquires throughout the land. This is how they get around not doing what they're supposed to do. So in Texas, on their website for the bar, it says that somebody is eligible to practice. But it doesn't say they're admitted to practice. And when you go look in the rules, you find out, well, what's the difference between eligible to practice and admitted to practice? People that are eligible to practice have done everything they need to do except take the oath. There's nobody in Texas apparently has taken their proper oath. Now, I don't know how they do it exactly in Kentucky, but I'm just saying, well, if James David Vance is the one that did it all right, and then you practice under James D. Vance, then you're practicing under a name that's not licensed to practice. Okay, continuing on then. When an applicant has passed the examination, the board shall certify the fact to the Supreme Court, and if approved, shall authorize the clerk of the court to issue a certificate of admission. So you're going to get some paper. Okay? Supreme Court has granted approval for the issuance of a certificate of admission based on the recommendations submitted under 1 and 2. The applicant must be admitted to the Kentucky bar within 2 years of said date. If the applicant fails to be admitted within a 2-year period, the applicant must make new application for admission. Administration of oath. So for all these different ones, which if you took the test in Kentucky, you fall under SCR 2.085. What you got to do, you got to pay the current dues and a final fee of $50 to the Kentucky Office of Bar Admissions. So we should check to see if, they got a receipt. And shall be administer the constitutional oath of office either by a justice of the Supreme Court or by the clerk of the Supreme Court. Upon completion of prerequisites, the clerk shall deliver to the applicant a certificate of admission on a form approved by the court, and the issuance of the certificate shall be duly recorded by the clerk. Okay, so that would mean that today that the clerk of the Supreme Court of Kentucky should be able to provide a certified copy of your certificate of admission. Not necessarily just the wall hanging. We're going to look at a couple of those in a second. Membership registration requirements and service. Each attorney licensed by the Supreme Court Practice Law Commonwealth shall, bada boom, bada bing, bada boo, include his or her 5-digit member identification number on all filings with courts of the Commonwealth and in all communications with the association. Well, I don't think that that's what's happening, and I'm going to show you an example. So it's kind of hard to find a document to look at in Kentucky. They don't necessarily have them all online to see like some states do, but I did find this for the Commonwealth of Kentucky in the Franklin Circuit Court, where Open Government Coalition wants to go against the Kentucky Department of Fish and Wildlife Commission. And it's a complaint. Okay. Well, first of all, the complaint should have been filled out by the Kentucky Open Government Coalition. One of their officers should have signed it. But instead, when we go down here and look at who did it, we see that Michael P. Abate is taking credit for it. Well, all these people here are attorneys, but none of them, or John, Michael, and William, are all listed in one form of name or the other on the Kentucky Bar website. But none of them here have put their freaking 5-digit number. Like I said here, include his or her 5-digit identification number on all filings with courts of the Commonwealth. But there isn't one. But not only that, there is no Michael P. Abate. There's a Michael Patrick Abate. And then it says Michael P. Abate up here, but which name is the name that's on the freaking certificate? Well, let's look at a certificate because, they have them out there. I call these a wall hanging, right? So here's a wall hanging for the Commonwealth of Kentucky. Supreme Court of Kentucky, Certificate of Admission to Practice Law. Now, I don't know that this is the form approved like it said in the rules, but this is what they give. And it looks pretty. It's got this lady's name, Lisa Michelle something on there. But it wasn't signed by the chief judge. So it's useless. This person's just attesting, right? So it wasn't signed by the clerk. The clerk was going to attest that the judge had signed it. It's not there. And on that same website then, I found this other one, Supreme Court of the United States of America. That's not the name of the court. The name of the court is the Supreme Court of the United States. Again, this is just, they just throw it in our face with all their different devious methods that they use. Just really close once again, because if you're in Kentucky and you're in court and you got attorneys involved and you just saw what I showed you, you should, start bitching about it. And say, well, this can't be a state court because the people aren't putting down their 5-digit number at the end. And this is the other thing. The court may approve or disapprove recommendations. If approved, shall authorize court to issue a certificate of admission. And this is what you want to see. You want to go to the clerk of the Supreme Court and tell him you want a certified copy of the record of the certificate of admission for the esquire that's prosecuting you and claiming to represent you. And just for the rest of us, JD, it'd be really good if you went and got yours and posted it online. So here's mine. Right? Go contact the clerk. Tell you need a certified copy of your record and put it online so we can all look at it. So we can see what's going on. Quit hiding shit. Okay, well, you're still here. Thank you. And that was going around the block one time with J.D. Vance. He's an enlistee. He volunteered. According to UCMJ, you're still under the UCMJ. And my brother, you can go use the UCMJ. Please go find a general court-martial convening authority and file some specifications and charges. Or get them to the convening authority to issue convene a court of inquiry, because then they can issue subpoenas, they can do an investigation, have them start rooting around. Just get all the details. That's how they get her done. Okay, very good. Everyone have a great day, and we'll see what comes up next. See you now.